I am standing in the International Tribunal for the Law of the Sea, where the reading of the advisory opinion from the Commission of Small Island States by the Tribunal just has finished. And I dare say that today might be one of the most important days of the whole year for marine protection. With certainty, I can say that this advisory opinion is definitely a landmark win and gives very important updates and information on the obligations of states to protect and preserve the marine environment. Why? Listen to these key facts. As we anticipated, the full tribunal did accept its jurisdiction over such advisory opinions. Second, ITLOS established for the validity of scientific evidence, the ITLOS must refer to acknowledged bodies and frameworks such as UNFCCC. This means that in future we can rely that the tribunal and courts will adhere and refer to those existing frameworks so that they are being given effect. Third, anthropogenic greenhouse gas emissions, GHG emissions, fall under the definition of pollution under UNCLOS because the adverse effects of climate change causes ocean acidification, sea level rise, and multiple deleterious effects on the marine environment. Therefore, states are obliged to reduce GHG emissions. This is an obligation of conduct and not result. The stringency of the measures that states have to adopt depends on various factors and must also take into account cumulative effects, such as the greenhouse gas emissions that already exist in the atmosphere. It therefore also includes the reduction of GHG emissions. The measures must furthermore adhere to the best scientific evidence, respect the precautionary approach, and the environmental impact assessment. This is super important for future cases because states are not only obliged to protect the marine environment when we know that the activity will surely harm the marine environment, but also where there is not enough scientific evidence, so we don't know it. Furthermore, the stringency of the measure is determined by the severity of the effect. Because of the severe and irreversible effect of GHG emissions, the measures to protect the marine environment must be stringent. The preservation of the marine environment also includes restoring and conserving it. Where greenhouse gas emissions also affect the marine environment of other states, the standard must be even higher. Developing states and low-lying states are particularly vulnerable to effects of climate change, and this must be taken into account. So what have we learned? The obligation to protect and preserve the marine environment is one of conduct, so it is determined by the due diligence of states. The stringency of the due diligence is determined by the severity of the activity and the effects of the marine environment. Furthermore, the ITLOS really supported that we need to rely on best scientific evidence. It stressed the necessity of adhering to the precautionary approach and environmental impact assessment. From a perspective of marine protection, this certainly is a landmark win, and this certainly can be the impetus for many more marine protection and ocean litigation cases to come.